think that, at least for me, what has always drawn my attention to the ITC is that it is a fairly collaborative and yet aggressive forum for building a detailed factual record around which you can gather a host of, let's call it, opinions. And so if you're the kind of client or lawyer who thinks you have the facts and the arguments and the goods, then that's the kind of process you ought to be drawn towards, because it's where a record will show the facts, and it's where the arguments can be reflected in the opinions, and the disagreements that people might have won't be elided. They will be available and fleshed out. And if you're confident in yours, that's where you want to go.
Josh?
Well, I agree with all that. In particular, collaborative yet aggressive is a great way to describe the ITC. I think it's an interesting time to be an ITC practitioner. I think we're on the precipice of what could be a new era in Section 337 litigation for a few different reasons. So first of all, the Lashify decision, as you mentioned. This is a decision that issued a few months ago from the Federal Circuit. Just a 30,000-foot view, it changes the ITC's approach to the domestic industry requirement. It's fundamental requirement for a complainant to obtain relief. The ITC had been interpreting its statute for one way for nearly 40 years. The Federal Circuit said, you've been getting it wrong this whole time. And the way in which the domestic industry requirement will be applied going forward, most likely, could really open up the ITC to new industries, new types of businesses, and I think it'll be interesting to see what happens in that respect.
Yeah, and new sizes of businesses and new patent owners as well.
Indeed.
We're going to talk about all that stuff. And we should probably start with maybe just so everybody's on the same page, just sort of basically what was Lashify, what was the case about? And Josh, you want to maybe just fill those gaps in a little bit? And,
Sure.
And Scott, I'll ask you for your additions as well, but go ahead, Josh.
Sure. Just at a very high level, Lashify is a relatively new company founded by a sole inventor. Its main line of business is a DIY solution for applying artificial eyelash extensions. They also sell the applicators and the eyelashes and the sort of components that are needed to install the artificial eyelashes. This sole inventor was very successful in building up her business. She grew it from a single person operation to over 100 people in her employment. The business model was primarily Lashify sells its products through e-commerce outlets, Amazon and Walmart and so forth. They do their distribution and sales and marketing and whatever ongoing R&D they have in the United States, but use foreign contract manufacturers, primarily in China, to manufacture and assemble their products. Lashify was, as many e-commerce companies experienced, Lashify was facing a lot of competition from primarily Chinese companies who were kind of copycat companies who were doing similar things and similar products. As many companies like Lashify do, they sought relief at the ITC and filed a Section 337 complaint, asserting 3 patents, 1 utility patent that went to the method of installing maybe installing is the wrong term, but applying the artificial eyelashes, and then 2 design patents. The ITC found infringement, not for all of the respondents, all of the accused infringers, but for a good number of them, for at least the design patents, and there's a little bit of an issue with the utility patent that probably is not as relevant. But the ITC found that Lashify failed to satisfy the domestic industry requirement. Why was that? The vast majority of the investments that, maybe I should back up, to satisfy the domestic industry requirement, a complainant needs to show that there's been significant or substantial investment in the United States related to the patented product. Lashify's investments that it relied on to satisfy the domestic industry requirement primarily related to activities like sales, marketing, warehousing, distribution, and some quality control. Those types of activities historically had been somewhat disfavored by the ITC. The ITC has a long history of disallowing investments related to sales and marketing for satisfying the domestic industry requirement, at least unless there's like other types of investments such as manufacturing and R&D investments and those sort of things. Warehousing, distribution, quality control, those types of activities have a bit of a checkered history as well. In some cases, the ITC has counted them, in other cases not, and probably the prevailing sentiment had been not to allow those types of investments. After the ITC issued its final determination of no violation, there was an appeal to the Federal Circuit. The Federal Circuit held that the ITC's application of the domestic industry requirement was incorrect. The statute does not specify certain types of activities. It says plant and equipment, labor or capital. And for labor and capital in particular, the Federal Circuit looked to the generally understood meanings of those terms in 1988 when the statute was amended. Those are very broad terms. Labor is a broad term, capital is a broad term. And the Federal Circuit said, well, labor does not exclude sales and marketing. And labor means the products and services that are in demand to the economy. And so sales and marketing can be used to further the success of products in the economy, and so therefore the ITC should have included them. And then the Federal Circuit remanded to the ITC to determine essentially, well, if we count Lashify sales and marketing and warehousing and distribution expenses, are they significant? Are they substantial?
Mm-hmm. And just last week, the ITC has asked the Federal Circuit to reconsider.
Indeed, yes. They filed a petition for rehearing and rehearing en banc.
So the ITC, not surprisingly, thinks they're correct and that the Federal Circuit is wrong, and so we'll see. The Federal Circuit is not a court, and most courts are not one to make a decision and then immediately say, "Oh, well, we got it wrong." So
Yep.
Likely not going anywhere, but to be continued there. So Scott, anything else to add of significance from your point of view?
Yeah, so first of all, I think you both have joined this issue really in a really helpful way because you've focused in on the key issues and topics. You've grounded it in specific statute, specific case law. So you've been both concise and complete. So, in one sense, how could anyone add to that?
Right. But I have confidence in you.
I will try, and I will try.
He said in one sense.
Yeah, in one sense.
And so, if
so that's the thing. You can always add, and whatever you say is always just like after you get done talking, it's like, well, why didn't I think of that?
Well, here's what I think. We're in an IP-heavy audience. Mm-hmm. IP-heavy audiences often remember high school physics, and high school physics force diagrams, and you're drawing out. Maybe you've got an anvil or a brick being pulled on a desk by a string, and you're getting tension on the string, and you're starting to label your force diagram, and your physics teacher leans over your shoulder and says, by the way, I just want to remind you that whole friction thing in your model, that only exists because there's this gravity force. You got to remember G, that's a biggie here. If you forget G in your force diagram, it's not going to stop the anvil from falling when it gets to the edge of the desk. G is going to still be there even if you forgot it. And forgetting it or leaving it out of your diagram won't stop your toe from hurting when the anvil falls on your toe. So what's the G in this force diagram? P, politics. So what I think I would just offer is, let's call it politics and context, the G, some of the bigger forces here. So first let's go back. Let's go back in history, 88, but also 1988, but then let's also go back to the 1800s. Most of the multi-member commissions in the US government, the Federal Trade Commission, the Securities and Exchange Commission, entities like that, they are, roughly speaking, New Deal entities, and they have a particular structure, particular time, particular structure. The ITC is anchored in a different time and built in a different way. It's anchored in the shadow of the Civil War, and it's structured in the shadow of the Civil War deliberately to engage the big P, politics, in a fundamentally different way than all of those other multi-body entities. They, the others, are 5-membered bodies. 5, this is not complicated math for a morning session. 5's an odd number. That means there's always a majority in the president's party. They have a chair. Depending on the particular statutes, depending on the litigation around Humphrey's executor, et cetera, their chair can essentially stay or be removed by the president. There's some debate in modern litigation about whether a commissioner or a board member can be removed from their seat, but the chair can be removed. The ITC is 6 members. 6 is an even number. That's not an accident. The chair is required by statute to rotate person and party every 2 years, regardless of whether the president acts or doesn't act. And so the ITC is designed for deadlock. If when my team has the chair, your time on the agenda is less than mine, in 23 months, I can predict that my team on the agenda will be less than yours was when we had the power. Because goose gander. If when your office gets assigned, it's smaller than mine, then in 23 months, I can predict my office will be smaller than yours. And in the winter, it'll be in Nome, Alaska, and in the summer, it'll be in Arizona, right? Without a roof. That's just power politics. That's how the game is played always in politics. So the ITC is designed deliberately to coerce collaboration among the two teams by setting them in opposition with each other. All of those other entities are not designed for that. They are designed for imbalance, not balance. They're designed to let a lot of flexing occur. The ITC is designed to coerce less flexing because there's retribution 23 months later or sooner. So what does that then mean? What that then means is the ITC has, roughly speaking, 5 jobs. The 337 docket is one of its operational units. It's got 4 others. One of the other large operational units is what people call the anti-dumping countervailing duty, or Title VII docket. In that docket, the ITC's role is to adjudicate harm, a type of harm that is analogous to the protective function around the domestic industry. The amendments to the various parts of the ITC statutes have generally moved along over the history of the Commission at around the same time frames. And so a then Senate staffer who was heavily involved in the interpretation of the ITC's Title VII harm docket, a person who many IP lawyers might not have paid much attention to, but trade lawyers paid attention to, is someone who's since become much more relevant because he left the Senate. He eventually went to a law firm. He eventually became USTR, Robert Lighthizer. When Bob was working in the Senate staff around the definition of the word harm, he was quoted as saying, mere psychological harm is enough. Okay, so what does that mean to us? You're patent litigators, many of you. You're used to litigating around technical or economic data. And as Josh discussed, the ITC's 337 docket used to, in the 337 area, really look at, let's call it a plant, equipment, and they look at how many gears and how expensive were the gears. So the technology and the cash of the plant and the equipment. But if in the Title VII, right around the corner, next door neighbor docket, I'm afraid mere psychological harm is enough, we can't today be surprised that people are saying, well, that way of thinking ought to then also apply in the 337 docket. Mere psychological harm is enough, or something akin to it. Now, I use this quote because it is in fact a quote, and Ambassador Lighthizer has embraced it in all seriousness. I don't think he meant it as a quip, and I don't think he was being silly. He's a serious person. But he was trying to frame people's thinking about the anti-dumping, countervailing duty, let's call it powers. And that way of thinking is at least analogous to this more expansive way of thinking in the 337 area. So that's part of, let's call it, the power, the P, or back to high school physics, the G of gravity. The other part of it is what you, Gene, were highlighting, which is the Federal Circuit is not a court that is shy about asserting an ability to tell lower tribunals, you, the lower tribunal, need to reframe your thinking. That's another big part of the P, or power here, or politics here. So you've got the trade community pushing, you've got the structure of the court system pushing, and then you've got, back down into the history and the weeds of the ITC, the ITC 6 members, if you go to the ITC's webpage and start counting, you'll notice, first of all, 3 of the seats are empty. The other thing you'll notice is the other 3 are, I believe, all 3 in expired terms, which means any day there could be a nomination of an entire new slate of ITC commissioners. You could see 6 nominees like that. And as long as the Senate has the political party of the president in the majority, confirmations can go quickly. So you could see a raft or a suite of direction changing events at the ITC, and that could go along with or be relevant to whatever the Federal Circuit does in this space.
So there's a lot on the table here, and we're going to try and dive into what's likely to happen here, and the players and what they think. And this issue's gone on for a long time. I have just two thoughts before we go a layer deeper here. One is just to refresh everybody's recollection. The reason that this matters so much in the patent space for patent owners is because the ITC is not bound by the Supreme Court's eBay decision. So you actually can get injunctive relief. Now, it's not called an injunction, it's a cease and desist order or something like that.
An exclusion order.
Exclusion order. Those are the two forms of injunctive relief that the ITC give. You can't get money there, but if you are a patent owner and somebody's infringing you, it is a very, very powerful thing to get them to stop. And it has become a big part of global patent litigation to increase leverage. So now there's that piece. Then there's the other piece is that simply was not available to small companies, and it's certainly not available to individuals for a very long time. So it became very important for, I think, a lot of people that something be done. And I've already said here, and I've written about this, and I talk about it a lot. I don't see a lot of distinction between the Lashify business model and Apple's business model. You know, obviously they relate to totally different technologies, and there's a totally different scale and a totally different number of people who are employed. But if you were to basically thumbnail sketch on a page Apple's business plan and Lashify's business plan and not put the name of the company at the top, they could be interchangeable.
I don't think that's accurate. Apple, back during the smartphone wars, the ITC was one of the forums that Apple chose to litigate against Samsung. I know because I represented Apple in the ITC. I also think there are some, I mean, we're painting with a little bit of a broad brush in saying that Apple's business model is akin to Lashify's business model. Apple is orders of magnitude bigger. That's not the only difference. There is another significant difference in that Apple has a massive R&D operation in the U.S., which R&D is one of the types of activities that the ITC has historically favored. So we have to keep that in mind. Lashify, one of the issues that it had was that there were evidentiary problems with its reliance on R&D investments. So really the only investments that it could submit as part of its domestic industry proof were these sales and marketing investments, warehousing, distribution, so forth. One of the other points that you made in terms of like whether small or medium-sized companies could use the ITC, I think Lashify certainly is the most extreme example of a small company who has a certain business model who can now utilize the ITC. But this is a trend that goes back a little ways in terms of smaller and medium-sized businesses having more success.
It was one of the questions I wanted to ask you, because you said, and I think that this is how it was characterized, and I'm not saying you're wrong or I disagree with you. You said that the Federal Circuit basically told the ITC that you've been getting it wrong all along.
Yeah.
I wonder whether that's what they really said, or is it that, you know, given our sensibilities in 2025, we think it shouldn't be that way anymore. So we're making a change, you know, and I've already mentioned a couple times the America First agenda, and I don't know that you can divorce that here, because we would love to have things come back and manufacture back, but that's just not the reality yet. Manufacturing is overseas pretty much for everybody. And small players have had the opportunity to take advantage of that as well in ways that, you know, 10, 20 years ago they wouldn't have been able to.
Yeah.
Well, go ahead.
So I'm in the they've been getting it wrong for 40 years camp. And I think there is something we haven't mentioned, an intervening event between the Federal Circuit decision and the ITC's final determination in this case, which is the end of Chevron deference.
Right.
And that gave the Federal Circuit an opportunity to kind of go back in time, re-examine the statute, Their decision is very grounded in statutory interpretation rather than in policy considerations. So I do think it's more the case of, well,
No, I get that.
we've gone off course,
Yeah.
and let's course correct. One more quick
Sure.
point in terms of manufacturing. If you look at the ITC as favoring certain types of activities over others, and historically, manufacturing was one of the favored activities, and sales and marketing were disfavored. And the result of Lashify is that sales and marketing is now favored. They're all on the same level. Well, then there are less incentives to invest in manufacturing in the U.S. So
Right.
you could actually think of Lashify as maybe an impediment to restoring manufacturing jobs in the U.S. To the extent that Section 337 has any impact on manufacturing, U.S. manufacturing or onshoring or anything like that.
Right, right. And the only reason I said I want to kick it around whether they said it was they got it wrong all along or whether this is just new sensibilities is simply because I think, and Scott, you and I, we've talked about this a number of times. Oftentimes courts, although they'll never admit to this, but it's clear, they see which way the wind is blowing. And they, not, I wouldn't say jump on the bandwagon, but the judges, I know judges read IPWatchdog. I know that they read, Dennis Crouch. I know that they read the Wall Street Journal and other things like that. And when you're consuming that information over and over again, it does kind of influence you, not in a bad way, but it does expand your mind to other things that you may not have thought about.
Let's notice a few, let's call it large magnitude things.
Sure.
Okay, so one is a lot of, let's call it large Silicon Valley-based companies, including Apple, have generally taken the policy position that exclusionary effect around patents can be, let's just say, overused and is currently too much.
No disagreement there.
Okay, so by that, let's just call that a large player generally skeptical about the policy approach to the kind of enforcement effect you were highlighting.
Right.
Whatever similarities or differences around business model, there was a policy choice that was forcefully expressed consistently. So that observation, I think, is relevant to what you were discussing. I think the fact that Apple was seeking the type of enforcement it was seeking once or twice is in a gotcha way inconsistent with, let's call it, this bigger policy. But we're not here to do gotcha. We're here to do, let's call it, professional analysis, respecting that each side makes broader policy choices and also short-term opportunity choices, and those aren't always in line with each other on either side.
Sure.
So this is not no one's here to do gotcha either way. But I do think in the Apple-Samsung dust-up, and I want to be explicit, I did not serve any role on it, and therefore I feel comfortable talking about it as a professional observer rather than one wielding inside information or encumbered by a duty. So I'll just observe, a lot of the press, left, right, and center, covered that as a U.S. versus Korea case. And at least as an observer, through this lens of P politics, I always saw it more as a rather ordinary domestic political interaction between our government and a set of domestic industrial players. So at the time, Google had, early in the primary season for the run-up to our national presidential election, picked a candidate, Barack Obama, over the party's general favorite, Hillary Clinton. And Barack Obama ended up being the candidate that won the primary and won the national. And that interaction between the Obama team and the Google team was long celebrated, is overtly discussed. It is generally recognized. And on most trips to Silicon Valley, there were, let's call it, photo ops or meeting ops opportunities between, say, the White House team and the Google team. After the Apple-Samsung USTR intervention letter, you suddenly started to see, in addition, not instead, Tim Cook Apple interactions with the White House at a kind of similar level to the Eric Schmidt Google interactions with the White House. So as just someone who kind of generally watches the big political game interactions, to me that's consistent with normal domestic political economy. If you, as a focal point in Washington, are closely connected to one industrial player, you have your own self-interest in trying to make sure you remind yourself and that industrial player that there are others in the game. That in effect, Google had to be reminded that Apple exists too. And that three-legged stool destination suited the needs of Apple, Google, and the White House for these ordinary domestic political reasons, and that drove that case, I think, a lot more than US-Korea relationships or iPhone versus Samsung Galaxy competition, or exclusion orders good, exclusion orders bad debate, or ITC good or bad debate. It was about a whole lot of other things. Now, to be clear, this is not the only time this movie has been played for us. We saw this happen in the Apple-Samsung USTR intervention during the Obama team, but during the Biden team, we saw a very similar play get played out around the Korea battery case.
I was involved in that as well.
And so, again, I don't want to put any of these parties in a spotlight. That's not the goal of this. The goal of this is to help us all as professionals notice the moves being played. And these are varsity moves. They're good, skilled moves. They're well-grounded in law. They're well-grounded in morality. They're practiced. This is not a shame on anybody point. This is a time to just notice that the power to convene at the focal point of USTR or the White House can be a way to, let's go back to where we started, aggressively collaborate.
Sure.
Yeah.
And it's worth noticing that in the Korea battery case, the outcome was not party A wins, party B wins, party A loses, party B loses. The outcome in the Korean battery case was a Sunday announced settlement. And the discussions included not just party A and party B, but senators A and B, governor A,
And
representatives.
other industrialists as well.
Precisely.
Yeah.
So it was a convening and a rugby scrum of negotiating and a deal.
So you said you don't want to make that a shame on you moment. I'm going to turn it into a shame on you moment because you weren't here the last couple days when
Correct,
I
I'm
brought up
sorry.
a couple times. Is shame on us in the pro patent community, right? I mean, this is what it means to, for lack of a better short way to say it, lobby, right? You know, lobbying is not about paying off somebody. Lobbying is about showing up. Lobbying is about touching the power base and trying to convince them of your position, and you do it over and over and over again. And there's nothing wrong about advocating on your behalf. You know, I think one of the things that is extremely admirable about what Silicon Valley has done, although I disagree with their policies, is they have single-mindedly tried to affect change in government and been very, very successful at doing so. And rather than vilifying them for that, we should look at that and say, there is a roadmap for us here that we can do this. And it's based on relationships. It's based on, you know, Google famously supported President Obama, and not surprisingly, President Obama had a lot of favorable policies that aligned with what was good for Google. Now, is that, the cynical person might say, well, that's, you know, payola, that's just a return. Google doesn't hire stupid people. They hire very competent lobbyists and very competent lawyers. And if you're talking to somebody who's very competent and very persuasive, they're going to make a lot of sense, and particularly if they're the only ones having the conversation.
Well,
because
also
we're not.
you'll also tend to recruit in that population.
Right,
pool.
you want to work with people who you're familiar with and that you like and that you get along with. And we have just, on our side, the pro-patent side, has so forfeited good common sense when it comes to business and relationships and affecting change. And so I do think it's shame on us, because the roadmap is out there to be seen. It's not like anybody's hiding it.
Yeah. So I don't want to give a misimpression of Section 337 litigation. We're talking about a very small sliver involving massive companies and really significant disputes. The bread and butter of Section 337 investigations, really, yes, if you get to the end of the process, there can be a lobbying, persuasion, political aspect to it. Most of the work occurs in front of an ALJ. There are bench trials. There's the development of an evidentiary record. And that looks a lot more like what patent litigators do in other forums in the United States.
And I'm curious, have you had much success taking that record and getting some leverage out of it in sister tribunals inside the U.S. or outside the U.S.? And what do you see as the opportunities there, or what do you see as the challenges there?
Yeah, I think personally, my experience has been two things. So first of all, very frequently, results in the ITC can be a huge driver of settlement. Yes, there are disputes in other forums, and they sometimes proceed in parallel, sometimes proceed in seriatim, where you are litigating the ITC first, and then there's a subsequent litigation in district court. Very frequently, the party that wins in the ITC has powerful leverage to get the dispute resolved. So I think that's a very frequent occurrence.
Yep.
It is. At other times, I do think the kind of specter of the ITC decision can have a role in the subsequent, let's say, district court proceedings. Yep. And it's something that the parties will try to spin in different ways. Yep. You know, somebody wins on infringement, somebody wins, on invalidity and so forth. And those decisions, those outcomes have different implications. Or, for example, winning on domestic industry from the commission, if you're a respondent, but losing on infringement in front of the ALJ, how do you take that if you're in a subsequent district court litigation? Well, the complainant, the patent owner, is going to think it won, and the respondent's going to think it won, right? And so when you get to the stage of trying to resolve that dispute or get the court, the district court, to pay attention to what happened in the ITC, there are a lot of different questions that occur. So these days I do enjoy my academic work, but I also have a consulting shop, and we do neutral services, mediation and arbitration. We also do
work where we're helping one side, and one of the things we're seeing a lot these days, I'm curious if you're seeing this, is we're noticing an increase in the number of multi-topic disputes. So maybe there's a patent, but there's also some trade secret issues, some false advertising issues, some market structure issues, design patent, copyright. We're also noticing these multi-venue disputes, and not just within the U.S., but in various European courts and agencies and Japanese and Korean. We're seeing it in China as well. Let's put China aside for a moment because there are some wrinkles there. But in these more friendly tribunals, and by friendly I mean similar to the U.S., friendly legal systems, systems that operate like the U.S., so Korea, Japan, Europe, UK. One of the things that sometimes we'll notice, both in our neutral work and in our party work, is that, no surprise, good lawyers are collaborating with good lawyers in country A or collaborating with good lawyers in country B. They're talking about the record. They're respecting secrecy orders. But you can, while respect and adhere to secrecy orders, point out, oh, there's vulnerability on the claim this party's making here. And are you seeing that kind of back pressure or feedback loop?
Of course, absolutely.
And that's an opportunity. It's an opportunity for the lawyers to be thinking about strategies that take in that insight.
Sure.
And I want to go back to something that you said, and I understand that the opportunity for political influence at the ITC is somewhat limited. Objectively, probably very limited, right? What I'm talking about is like there's this drip, right? It's the Google and Apple, since we're talking about that, those two, very, very good about getting their message out in the media to everyone. Both have fans. Probably everybody here has at least one Apple product. I've got multiple Apple products, although I don't like their patent policies. Their products are great. And so they're very, very good at doing that. So that message is getting out in the New York Times, and the Wall Street Journal, and the Washington Post, and as that message is getting out in meetings in D.C. with senators and members of Congress, and then with the president and the president's staff, all of these things add up over time, and that's how that's how most people do think it's they're just paying, there's a payment here. No, what it is it's an investment. They invest little by little to persuade you over a period of time, not knowing what's going to pay off.
So I have a thought about this, and I'm very interested in your perspective on it. I do think what you're saying is correct, and I think the kind of messaging, the political messaging that large actors like Apple and Samsung and other, let's say, frequent flyers at the ITC does have an impact. As a practitioner who never worked for the commission, I think one thing that most practitioners think is that the commission has a sense of self-preservation, and they don't want to push their interpretation of the statute too far in one direction or another so that they make it too easy for patent owners to succeed and get exclusion orders against the Apples and Samsungs of the world and so forth. I think it's interesting, standard essential patents are a frequent topic of conversation here. There's a lot of litigation of SEPs at the ITC. There are very few decisions that the commission issues on SEPs. And I think most practitioners think the commission finds some way to avoid making difficult decisions that will negatively impact a major player.
Yeah, and also I think that the parties are really hesitant to bring up SEP. You're fighting over SEPs. Everybody knows that they're SEPs, but it's not. It's almost this strange, choreographed, elaborate ritual where everybody knows what we're fighting over, but nobody actually says it. It's like it's a Harry Potter moment, like he who shall not be named. It's
Yeah,
like
so-
nobody will say Voldemort. Nobody at the ITC will say SCP.
So just again, structure goes a very long way in explaining behavior. The old Tariff Commission, which is what the ITC used to be called, it's now called the International Trade Commission, but that structure is really old and really deliberately designed for deadlock. And it is that coercive power of deadlock that accomplishes the outcome you're describing. So 9-year terms, staggered in the statute by 18 months, no more than 3 in one party, a chair required by statute to rotate person and party every 2 years, even if the president doesn't act. So that structure goes a long way. That's internal to the ITC. External to the ITC, I mentioned that it has 5 ops. It generally sees itself as having 3 bosses: the White House, the House Ways and Means Committee, and the Senate Finance Committee. And even when those 3 bosses are members of the same political party, those 3 bosses have their own selfish interest in bickering with each other and fighting with each other and throwing each other sharp elbows all the time. And that's even when they're in the same political party.
Yeah.
And they're often not in the same political party.
So just to kind of tie things back to Lashify, I think it's really what you said about the structure of the commission, the ideal structure of the commission, of there being deadlock as the goal. I think you could see what happens when there's not deadlock and there is an imbalance in Lashify, where when Lashify was decided by the commission, they were missing 1 commissioner, so it was 5 members. 3 of them, let's say, had a more historically conservative view of the domestic industry requirement. 2 of them did not. There were dissents on the commission decision. And so you got an interpretation in Lashify that was somewhat harsh to the patent owner. In the following the Lashify decision, 1 commissioner left. There were 4. Suddenly, you have deadlock again. In the meantime, there was another significant set of investigations related to domestic industry. We handled them. From what we understand, there was a significant deadlock among commissioners that went on for, I think, 9 months over the issue. There were some big questions. The Lashify type questions were involved in our cases. What ended up happening is the commissioners found some common ground to resolve the domestic injury question on much more narrowly, much more specific to the facts of the case. So a much more conservative outcome. And then another commissioner left. And now we're at 3. And now there's a petition for rehearing that's before the Federal Circuit that looks much more like the commission decision in Lashify. So, and it's the 3 who are still standing, 2 were in the majority in the original Lashify decision.
And keep in mind, all during a time of, let's just say, fairly intense presidential politics within both political parties, let alone between them, and fairly intense publicly revealed conflicts around personalities inside the ITC, including charges of harassment and stuff like that. Yeah. So, like, yikes, it's getting hot.
We're going long. This was a great conversation, and we're going to have to end it here. But very rapid fire, quick. Josh, final thoughts?
Sure. I think the way the discussion has gone, it says to me that the ITC is really kind of a microcosm of what's going on in the federal government more generally right now. I think on the ground, there's a lot of stability. When we litigate Section 337 investigations, they look the same as they did a year ago or 2 years ago or 5 years ago or 10 years ago. And you're in front of an ALJ who has a job to do and build a record and so forth. And then there's something else going on, which is the sort of political realm where there's just nothing but uncertainty right now. And we're all kind of, waiting around to see
Looking
what
around.
is going to happen.
When's the other shoe going to drop?
Yeah.
The only thing I'll just add is that your professional toolkit that you all have and that you've discussed is your saving grace here, that you can build and run your strategies with a mindfulness towards this degree of uncertainty at that political level, so that when you're doing the very hard and expensive work of that in the trenches litigation, like the good news, bad news story about the 337 docket is it's fast and expensive, right? That's bad news, it's fast and expensive, but it's good news, it doesn't take you that long, and it's not more expensive than district court litigation. So in a world of uncertainty, fast and expensive means high value. That means you can relatively quickly, relatively concisely build a relatively complete record. And as professionals, if you go into that with your eyes wide open and build your portfolio strategy, your web, your layered or textured approach, you can get pretty good outcomes. And as Josh, as you were pointing out, most of this is going to operate below the political level and be driven by the merits. So that's good news. It's not perfect news, but it's a lot better than cry in your soup bad news.
Awesome. Well, thank you.